So I'm having a meeting last week with a pain management doctor, and he's busy, very significant practice, does a lot of PIP, does a lot of workers' comp. And his question to me was, if I'm gonna be giving you guys my workers' comp claims to pursue, and you're telling me there's gonna be a good number, you're gonna do this 6-year review and find these claims, am I gonna spend all my time in court? I'd rather be working on patients. I don't want to spend my time in court. I say absolutely, I will say unequivocally, there's a 99.9% chance you won't have to step into a courtroom, okay? And here's why I say that. The way workers' comp court works is there is a process to get to a trial, but the overwhelming majority of these claims are settled prior to trial, okay? The workers' comp judges tend to be very good at pushing settlement, okay? So they have their hearings, and before they'll set a trial, before they'll set a date or a claim down for trial, they will do their utmost to make sure the parties have done everything they can to settle. They look at the insurance company as a big boy, they look at the medical provider as a big boy and say, you're big boys, come to some agreement. This is really a give and take between business entities. So, I don't want to bog down my courtroom with a trial, you guys settle. So they do a lot to push settlement, okay? So the overwhelming majority settle, which means they don't go to trial. In the event that they do go to trial, because the question is, what is the proper level of usual and customary payment? So in the instance, for example, the medical provider may have billed $20,000 and the medical provider says that's their usual and customary rate. And then the insurance carrier may be paid $2,000 and says, we think that's a good, reasonable, usual and customary rate. You don't need the medical provider in the courtroom to attest to that. So our witnesses, even if it does go to trial, which is very rare, are not going to be the medical provider himself. They're probably going to be maybe an industry expert that knows about billing for particular CPT codes. It may be the billing person of that medical provider who is a biller, licensed biller and coder, and can talk about usual and customary rates and how they arrived at the rates they billed. So the answer it is possible in some extraordinary circumstance that the medical provider might have to go to court, but to be honest with you, I've seen one instance where a surgeon has had to go to trial, and that surgeon really was insisting on going, given the circumstances of the case, and we were actually trying to discourage him from going because we thought the case should have settled at some level that we could have obtained, but he was kind of dug in and was going after the principle of certain things, and he insisted on testifying. So the answer really is a no, even though there might be some extraordinary instance where he has to go to court. So any other questions, feel free to give me a call here in Paramus, Tom LaGreca at Callagy Law. Would love to talk about this with any of you, and I'm very happy answering any and all questions you might have.